The Ministry of Finance imposed an administrative fine over the director of Yerevan Beer Closed Joint Stock Company, who applied to the administrative court demanding to cancel the decision of the Finance Ministry. He argued that the contested decision was published in a proceeding in which he was not properly informed and the time and place was not known. Thus, the administrative agency violated the plaintiff's right to be heard. In the absence of circumstances justifying the need for the inspection, the plaintiff prohibited the inspection, exercising a lawful behavior, while the Ministry of Finance showed unlawful conduct towards him. The court granted the citizen's request. Citizen Vartan Vartanyan filed a lawsuit to the administrative court against the Ministry of Finance, asking to annul the latter's decision. The administrative court found that the claim was well-founded and upheld the appeal, as the Ministry of Finance had based its decision on incorrect application of the Customs Code and the Code of Administrative Offences. A retired judge and a retired prosecutor submitted a complaint to the administrative court on the size of their pensions. The judge demanded to annul the relevant decision of the Ministry of Finance and the General Prosecutor's Office. The court found that the claim of the judge was legitimate and complied, but the prosecutor's claim was rejected. The Ministry of Finance and the retired prosecutor appealed against the decision of the administrative court. A video was posted on the internet on a terrible fact of death by torture of a wolf in Vahan village of Gerarkunik province. The video caused a heated response on Facebook. Outraged citizens suggested to get together and discuss the legal consequences of ill treatment of animals. They made their voice of protest and a petition to the Minister of Environment and the General Prosecutor's Office. The Ministry of Environment had denied the fact of illegality, and the Prosecutor General's Office conducted an investigation and issued penalty to the soldier that had tortured the animal to death. This release of the TV program also presented serious environmental problems existing in the country, the state and the international standards, and the importance of correcting the dominant wrong practices and establishing appropriate policies. Concerned citizens voiced their opinion on those issues. By the government's decision, the property rights for the former dormitory of the vocational school were granted to the workers that had lived there. The plaintiff was a woman who was not allocated an apartment since she moved to Russia in 1997. The woman went to court demanding her apartment. The court rejected the claim. The State Language Inspectorate initiated a lawsuit against the director of the Fashion Time company for placing a sign in foreign language above the entrance to the store that reads Fashion Time Shopping Store. State Language Inspectorate asked the court to issue administrative responsibility over the director of that company. The court upheld the claim and ruled that as public authorities, all businesses and organizations are required to use signs, all means of advertising, stamps, etc., in Armenian language combined with other languages if necessary. The Ministry of Finance filed an appeal with the administrative court, challenging the decision of the administrative court in favor of a citizen. The citizen was illegally subject to administrative liability and was fined 1,780,000 drams, and the administrative court upheld his claim. In their appeal, the representatives of the Ministry of Finance argued that the citizen was guilty and should not have been pardoned. The Court of Appeal dismissed the claim of the Ministry of Finance. Another citizen was recognized as the winner of an auction, and the Ashtarak municipality provided a contract for construction licensed for 30 years. But the mayor of Ashtarak had changed the decision and construction was banned. The plaintiff asked the court to annul the decision of the mayor of Ashtarak. The Administrative Court of Appeal has found that the plaintiff's request should be upheld. the Master Retail Closed Joint Stock Company filed a lawsuit against the Ministry of Finance. The ministry decided that the company must pay to the state budget additional customs duty and value-added tax as well as penalties. The company noted in the appeal that the current situation is caused by objective reasons and as a result of defective legislation. The court upheld the claim of the citizen. The traffic police had unlawfully penalized a driver. Meanwhile, the car belonged not to the plaintiff but to the company which he managed and was assigned to one of the company's employees. But police did not find on these circumstances, thus violating the law. The Court of Appeal upheld the claim of the citizen. The Intellectual Property Agency of the Ministry of Economy had registered the Tavern Old Yerevan trademark, and the owners of the Old Yerevan Tavern restaurant appealed to the court to invalidate that registration. According to the appellant, the trademarks sound confusingly similar. The Court of First Instance observed some procedural irregularities and wrong application of the law. However, the Court of Appeal rejected the appeal. Without good reason and in violation of the law, the management of different districts issued administrative penalties to citizens for discarding their unacceptable types of garbage in dumping areas. The issue covered two such litigations. The administrative court upheld the appeal and declared invalid the decisions of the leadership of those districts. In addition, we reflected on inadequate sanitation and hygiene in areas of responsibility of the municipality, in particular in the outskirts of Yerevan and in Hrazdan Gorge. A group of residents came to us complaining of stray dogs and inaction of the leadership of the various Yerevan districts. Some citizens even wanted to apply to the administrative court, but did not know how to file a lawsuit. Environmental non-governmental organizations that deal with the issues related to animals in the country strongly criticized the work of the Yerevan municipality and their position with regard to the problem of stray animals. Municipality paid a vast amount of money to solve this problem by killing of stray dogs. For years, they announced a tender in which always one company wins, the Unigraph X LLC. The environmentalists said that the amounts allocated and the results do not match. Instead of neutering the animals are slaughtered. On the other hand, the majority of population seems completely indifferent to the issue of stray animals and requires their complete elimination. Armenia joined the World Health Organization and the UN World Animal Health Organization, and these organizations emphasize that the mass extermination of stray animals is not only ineffective, but it also does not resolve the problem. The municipality of Yerevan imposed a fine over a driver for not paying for parking. The driver complained to court, which ruled in favor of plaintiff, as there were no road signs in the place where she parked the car. Another driver received a letter from the municipality informing that his car was parked twice in a paid parking lot without paying the fee. The court found the decision unfair and violating the law and granted the appeal. The court concluded that the law does not specify the deadline for payment of the fee, and therefore the administrative enforcement cannot be applied. A businessman submitted a claim against the Food Security Service of the Ministry of Agriculture on an unfair penalty he was imposed for prohibiting to conduct inspection in his store. The ministry representative failed to prove in the court that there was such an accident. The plaintiff referred to the law, which states that if a citizen is accused in misdemeanor, it is not the citizen who must prove that he or she violated the law, but the administrative body must prove the fact that the person violated the law. Meanwhile, there was no such evidence. According to his lawyer, Mr. Alumyan, 250,000 drams of the fine is not intended to compensate the losses caused by the plaintiff, but to punish him unfairly. It can be conditionally called administrative responsibility or criminal punishment. The tax inspectorate intended to check the legality of a store in the center of the city. However, the store employee obstructed this because of the absence of the store's owner. As a result, the tax inspectorate appointed an administrative punishment in the amount adequate to certain criminal offenses. The court found the claim lawful and satisfied it, but on the basis of the fact that the tax inspection did not prove the legality of their actions. However, the plaintiff's lawyer in the interview expressed the opinion that the law should indicate the maximum amount of the administrative fine, above which it can be regarded as criminal penalty. The tax department was investigating in a nightclub whether the staff hiring was done in accordance with the law. Inspectors found that 8 people were working illegally in the club. Then 8 turned into 7, but the company must pay a fine of 2,100,000 drams to the state budget. The nightclub appealed to the court to annul the decision for the other 4 employees. The court upheld the claim and concluded that the inspecting authority should have at least formulated and presented its doubts concerning the documents of those 4 employees. That concern should then have been addressed by the management of the nightclub. In this case, the inspection was carried out unilaterally, ignoring and not inspecting the evidence and the arguments of the plaintiff. The show addressed again the issues of the local government's approach to stray dogs and cats. Animal lovers and NGOs said that the position of local authorities and the mindset of the population should be blamed for the problem of stray animals. The best foreign practices were mentioned. There is no applicable law in Armenia, and that means that there is no punishment for those who keep animals unfed or cast them out or kill them. Meanwhile, the public discontent is not directed against those who commit crimes against animals, but against those who do not accept the current situation, the animal lovers. However, the local officials that can work even in the absence of appropriate legislation to improve the situation, in fact, do not initiate anything. The civic action group We Are Responsible for Those We Have Tamed has appealed with a new proposal to the City Hall, which is based on international experience and adapted to the conditions of the country. Yet the authorities have not expressed readiness to cooperate with civil society. A cooperative filed against the State Inspectorate of Market Surveillance of the Ministry of Economy. They asked the court to annul the decision regarding a fine. An investigation conducted at the cooperative revealed that the company is engaged in product import and sale without a certificate. During the trial, the plaintiff presented the certificate. The court granted the request as it was not proved that the plaintiff violated the mandatory requirements of normative documents. Pharmacy company that was subject to administrative punishment by the mayor of Yerevan since it did not make the required improvements in the surrounding area. The company stated in the complaint that the mayor does not have any legal basis for this conviction. The court found that the contested decision of the mayor was adopted in violation of the Code of Administrative Offenses and should be annulled. Private ownership and market economy was banned in the Soviet Union. Intellectual property is also a private ownership, but these types of property rights and court disputes were rare. Now, in market conditions, such judicial disputes have become commonplace. Also, trademarks are considered the intellectual property. A trademark must be registered. If it is registered, the state is obliged to protect the exclusive rights of the trademark owner. The program presented a similar dispute between the owners and explained to viewers just how important is the state registration to their business is. A civil suit against the district head's decision. He needed to pay property tax to the municipality, including a substantial penalty. He asked the court to apply the limitation of actions under the Civil Code and calculate the debt and penalties for the last 3 years. The court upheld the appeal. Viewers were given advice on the legality of such circumstances. Firstly, to check the amounts for such mistakes. And if the administrative body does not want to admit the mistake, the persons must continue the fight for protection of own rights and appeal to the administrative court. The Spanish company Zara. It was filed in the administrative court and thus invalidated state registration of the Zara Wines and Zara Wines Z. Tigrani trademarks, which are used by another company in Armenia that produces wines with these names. The end of the trial was covered in the 24th issue of the program. Administrative justice in the country was established in 2008 based on the German model of administrative justice. Financed by GIZ, experts of the German administrative justice regularly visit Yerevan. The first issue of the program, broadcast on 6 June of 2015, presented the opinions and expectations of Germany's well-known experts in administrative justice process. About a year later, we met again. Wolfgang Reimers, the retired president of the Supreme Administrative Court of Hessen, and Rudiger Rubele, professor, president of the German Federal Administrative Court, expressed their assessment of the development of administrative justice in Armenia. They consider that 70% of the court's judgments in favor of citizens are the evidence that state institutions are often violating the law. The program presented a trial in which an ex-wife appealed to the head of a district and was allowed to change the child's surname. The child's father went to court. The court declared invalid the district's decision to change the child's surname as it was made in violation of the law. A father of a child with disability against the Provincial Medical Social Expert Commission, so that the commission recognizes the disability of his son. Examination results and forensic medical conclusions were provided to the court, and a court-appointed expert was also invited to the hearing and testified. The court granted the plaintiff's claim and obliged to recognize the disability of the child. The continuation of the 21st program on Zara Company's intellectual property lawsuit against the Intellectual Ownership Agency of the Ministry of Economy, the abrogation of the registration of the Zara Wines and Zara Wines Z. Tigrani trademarks. The court ruled that Zara Wines, similar to the plaintiff's trademark Zara, verbal trademark, and Zara Wines Z. Tigrani trademark is identical or similar to the plaintiff's Zara verbal trademark. The court partly upheld the appeal. It recognized the state registration of the trademark Zara Wines void. Regarding the Zara Wines Z. Tigran, the court rejected the claim for invalidity of the trademark. The program explained to the viewers that the legislative requirements relating to registration of trademarks. By the decision of the Court of First Instance, 10 residents from one of the provinces should have paid to a bank $6,109. Mortgaged properties were the 2 arable parcels of land and a dwelling with its adjacent land. And even though the land parcels were estimated much lower than their real value, that amount was sufficient to fulfill the requirement of the bank. But the bailiff had sold a residential house that belonged to one woman and the adjacent land. They were sold for only 2 million drams, although the house was valued at about 25 million drams, and the starting price exceeded 18 million. The woman appealed to the administrative court. The court stated that according to the state constitution and the European Convention principles, each case should be resolved to avoid the biggest inconvenience to the debtor. In this case, it was the loss of the home. The administrative court upheld the claim. Who is liable in case of violation of the traffic rules? The vehicle owner or the driver of the vehicle? A woman reported her complaint to the court that the traffic police has issued fines to her and not the person who drove the car and committed violations. She was not given a chance to prove her innocence. The law defines the administrative responsibility of the vehicle owner for this violation, and if the car is owned by a legal entity, the administrative responsibility takes the person attached to the vehicle. The plaintiff is the owner of the vehicle, therefore, the traffic police acted within the law. Therefore, the plaintiff's claim was rejected. A woman filed a lawsuit against her municipality. She parked her car for not more than 10-15 minutes, and then she went out and came back again. But the parking exceeded the specified free of charge duration. The record was made in the absence of the plaintiff, and she was not informed. The case was heard in the absence of the plaintiff. The trial confirmed that she was not notified of the investigation. Meanwhile, the right to be heard is a fundamental human right, and the court granted the appeal. According to the law, the road signs must be visible from a distance. The plaintiff, a woman, had to go to court against the traffic police. As an experienced driver, she made a left turn and it never crossed her mind that the relevant road sign was changed. As the court observed that the sign was invisible on the video from the side, granted the request. A company was declared bankrupt by a court ruling. Compulsory Enforcement Service levied the company 11,500,000 drams, but then transferred a portion of that amount to the special bankruptcy account of the company. The bankruptcy manager asked the court to return the full amount levied on demand. However, for unknown reasons, the court granted the request in part. The company appealed to the Court of Appeals. The issue was on a property dispute between two brothers regarding the yard of their house. The court concluded that the plaintiff's claim has no legal and factual grounds. The TV show explained the law to the viewers. The police and tax service of the Armavir province called for the administrative responsibility of one of the poor residents who allegedly, being engaged in car repair business, concealed his income and evaded to pay to the state budget $5,000 for taxes. That citizen appealed to the court and, not having the means for a lawyer, he himself defended his rights. The court found out that there is no evidence that this person is engaged in unregistered business. The court decided in favor of this citizen. It was on the conflict between the former spouses about the surname of their child. After the divorce, the woman asked the municipality to change the surname of her 10-year-old son to hers. The municipality granted the request as the boy was at an age when he could express his attitude to the change of the family name and expressed his consent. The father of the child presented the legal action against the decision of the municipality. But the court dismissed the claim, considering that the change in the name of the child was legal. The telecast explained that norms of the law related to changing the name of the child. Administrative responsibility or criminal punishment. The tax inspectorate intended to check the legality of a store in the center of the city. However, the store employee obstructed to this because of the absence of the store's owner. As a result, the tax inspectorate appointed an administrative punishment in the amount adequate to certain criminal offenses. The owner of the store filed a lawsuit against the tax inspection to the administrative court. The court found that the claim was lawful and satisfied it, but on the basis of the fact that the tax inspection did not prove the legality of their actions. However, the plaintiff's lawyer in the interview at the end of the telecast expressed the opinion that the law should indicate the maximum amount of the administrative fine, above which it can be regarded as a criminal penalty. A woman filed a lawsuit against the customs service, which imposed a fine of over 26 million Armenian drams. However, the woman was not even invited to the departmental discussion at the Ministry of Finance. The court granted her claim, recognizing the illegal actions of the Customs Department. The court recognized the priority of the right of citizens and legal entities to be heard, that is, their right to self-defense at the prejudicial level during the consideration of the conflict at the agency. One of the houses of Yerevan was recognized to be in the emergency situation, and the government paid damages to the residents. One of the residents to this house filed a lawsuit against the government. In addition to the apartment in which he lived, he owned a large non-residential area, but for the loss of this property, he was not compensated because there was no such provision in the law. There is a draft law, but for 8 years now, it has not been considered by the parliament. The court satisfied the citizens' claim by obliging the government to compensate the plaintiff for the damage caused. The government's response to this issue of the TV program was sharply negative. 2 women called to the TV program about the conflict with Ucom's telephone company. The company appealed to a court against one of these women with a claim for payment of a debt for the use of mobile communications. The second woman told a story that the company sold her an out-of-order mobile phone. The main problem was that these women at one time signed a contract with the company, not acquainted with the terms and conditions. The TV program urged citizens to carefully familiarize themselves with the terms of any agreement which they are offered, and not only by telephone companies. Mental health of the population is a national security issue. Discerning between mental health and mental illness have always been problematic for the justice system of any country. The former Soviet Union had no legislation regulating the field of mental health, and psychiatric hospitals often were filled with political opponents of the regime. Post-Soviet countries, including Armenia, adopted national legislation governing the sector, which are aligned to the international law. But as it often happens, the reality is away from the legislative requirements. The TV program explained these issues. On July 2, 2016, our program introduced the trial about illegal actions of the executors of the Gerarkunik province, because of which a large rural family was left homeless. The administrative court rectified that illegality. However, the compulsory service and the citizen who bought the house for inadequately small amount of money filed an appeal to the Administrative Court of Appeals. The latter rejected the appeals and left the decision of the lower court unchanged, since it was made in accordance with the principles of the law and the European Court of Human Rights. The traffic police in Dilijan fined the driver for gross violation of traffic rules without having evidence of the misdemeanor by that driver. In part, the cameras available on the crossroad did not record such violation. The fined driver applied to the administrative court, and the court ruled in favor of the driver. A young man went to Nagorno-Karabakh in 1992 to participate in the war and never came back. He was announced as missing. His mother started to receive special pension for losing the breadwinner. In 2010, the Kotaik Mars First Instance Court of General Jurisdiction approved the fact that the young man participated in the war actions and was gone missing since 1992, May 21. However, starting September 2014, the mother stopped receiving the pension on the basis that the statement provided by the Defense Ministry was false. A criminal case was launched, which was then closed as it was established that the soldier was indeed missing. Notwithstanding the closure of the criminal case, the mother's pension was not recovered and the unpaid funds were never paid. The mother applied to administrative court. The plaintiff never has participated in the administrative proceedings initiated by the Ministry of Defense. She simply was not notified. She learned about being deprived of the pension only by the fact not receiving it. The administrative court found in favor of the plaintiff. It established that the plaintiff was not informed or notified on the date and time of the proceedings. She has never been invited to participate in the hearing. Her right to be heard was violated, and as such, her constitutional rights and the rights protected by the European Convention on Human Rights have been violated.